Maybe.
This POXO again.
Yes.
Yes.
Heard Mr. J. Ahmed, learned counsel for the appellant, who submits that the judgment dated 24/2/23 passed by the court of the special judge bracket POXO, Baksa, in special POXO case number 16/2022, by which the appellant has been convicted under section 4 of the POXO Act 2012, should be set aside. Issue notice returnable in 4 weeks. Ms. S. Jahan, additional PP accept notice on behalf of the state. Appellant to take steps for service of notice upon the respondent number 2 by registered post with AD within
2 days.
2 days. List the matter after 4 weeks.
There's an IA.
That may
In
be
the IA, right?
Consider.
This is an application under section 389 CRPC for suspending the sentence and releasing the applicant on bail. Ms. S. Jahan, additional PP is granted 4 weeks time to file written objection.
No.
This is a matter of 4 weeks.
Who is an NDPS matter? Yes.
Please, your lordship.
Miss,
Lordship,
your name?
AK Boro lordship.
We heard Mr. A.K. Boro, learned counsel for the appellant, who submits that the judgment dated 9/3/23 passed by the special court Bongaigaon in special bracket NAR bracket close case number 23 bracket BGN bracket close of 2022, by which the appellant has been convicted under section 20B 2C /29 NDPS. 29 also
Yes, lordship.
should be set aside. Ms. S. Jahan accepts notice on behalf of the state. Before that, admit the appeal, call for the LCR. Ms. S. Jahan accepts additional PP accepts notice on behalf of the state. This is a matter of the 4 weeks.
There is an IA also for suspension.
In the IA, right? This is an application under section 389 for suspending the sentence and releasing the applicant on bail. Ms. S. Jahan, additional PP is granted 4 weeks time to file written objection.
Respondent number 2, I'm appearing for him as well.
Okay, she's
He's the
appearing for
ASI.
GSA for both, accept notice on behalf of both the respondents.
Yes.
In the main appeal, you're right.
Lordship.
That's all.
Online.
5 is a leave application. Item 4, I think he's appearing.
Who's appearing for item 4?
Item 5. 4, Mr. Mitra is appearing.
We have already issued, you want your name? You want your name there?
Yes, ma'am.
Okay, you put instead of his name, you put Mr.
Yes, Mitra.
S. Mitra's name. Okay.
5, this is a leave application that has come up before your.
Yes, any objection, madam?
My lord, may the matter be adjourned for next.
No. What is there to object? What is there to
My lord,
adjourn?
I am here on behalf of my senior, Mr. G. Chaudhary.
Huh?
I am here on behalf for my senior, Mr.
Where is he?
Chaudhary.
Where is he?
He is engaged in some
Other matter. Well, he's not coming here. How long will he be engaged? Whole day?
My lord, may the matter be pass over for the time being.
Okay, for the timing, 5 minutes. Tell him to
Got it.
come. We are allowing this application. Otherwise, if he doesn't come.
May I please your lordship, and may I appeal your lordship. There is an IA for stay your lordship of the order passed by the family court, your lordship. Thus, because your lordship, the order that is passed is with your lordship, the petition is directed to pay 10 lakh rupees as permanent alimony, your lordship. But on my side, your lordship is too high for me. Your lordship just stay, your lordship. Your lordship, I will pay the other amount, your lordship.
How much will you, let us see, what is the amount? Vivek?
10 lakhs, your lordship.
So how much can you pay?
Your lordship, I have some policies, your lordship. I can break that policies, your lordship. I am paying a joint policy of both the petitioner and the wife, your lordship, and one policy is in my name. And
Madam,
your
I'm
lordship,
not saying how many policies or what policies, where, how much can you pay?
It's not, it's about, it's not, your lordship, I'm not able to pay 10 lakhs, your lordship, but less than 10 lakhs, I will able to pay, your
How
lordship.
much, how much? Less than 10 lakhs is how much? 1 rupee, 2 rupee,
Your lordship. 2
say
lakhs,
8 lakhs, 9 lakhs,
3
how much?
lakhs, 3 lakhs, your lordship, not more
2
than
lakhs.
that. Yet, but your lordship, a stay, it will be given your lordship, I can arrange something, your lordship. But your lordship, at present, your lordship.
What
your
are you
lordship, they
working
have,
as?
filed an
What are you doing? What work do you have?
Your lordship, earlier there was a wholesale shop, your lordship, but due to the pandemic, lordship, the same shop has been closed, your lordship, and presently I am working as an manager in a Jal Jeevan mission, your lordship, and my salary is 15,000, your lordship only.
Well, all these facts were never brought before the learned trial
Ah.
court. That-
Because your lordship, during that time, your lordship, my shop was closed, your lordship, and now presently after pandemic, your lordship, I'm able to, recently I'm able to
My lord, if I
engage
may-
myself in.
You deposit 50%.
my lord, if I may
50%.
place a
Huh?
judgment of the Honorable
Yes,
Bombay High
yes,
Court,
please.
it says that 75% of the amount needs to be
Okay.
deposited for stay.
Your lordship, 50%, your lordship.
And the
is
amount
high on
in
my end, your
in that
lordship.
particular matter was way
10
high,
lakhs
way
only,
more high. It was
5
11
lakhs, your
crores.
lordship is-
Huh?
In the judgment, that the judgment which has been passed by the Bombay High Court, in that particular matter, the wife was there and only one child was there. And the amount that was granted was 11 crores. The court had directed deposit
Madam,
of
those are rich
75%.
persons, 11 crores, those are rich.
In
persons.
this particular matter, my lord, the petitioner is taking care of two children, one son who is studying and a younger daughter. My lord, and for all the three of them, the total amount that has been granted by the learned trial court is rupees 10 lakhs.
No,
Now,
your-
my lord, taking care of the children is also a
Your
burden on
lordship,
the
I am
wife,
ready to take care
especially
of
when
my.
she's not a working person.
She's
And
working.
if your lordship kindly takes the memo of appeal.
Look, madam, one thing you've got to understand. This 5 lakhs that you're going to get, or this 10 lakhs that they're supposed to get, it's not going to be finished off in a couple of months. It is supposed to be there for some time. So during that time, the appeal will be disposed of. Maybe it'll take some time, but it will be disposed of. It doesn't mean that the amount that has been given here will be finished off in 1-2 months by you. What do you think? You're going to blow it up? You're going to go for a party or something like that?
Definitely not, my
then-
lord. They belong to a small village. They
then-
don't have any
then-
means of earning.
So even if you get 50%, and if the matter is disposed of in the coming months or in a year, then how does it prejudice you? It's not that you're going to dispose of the entire money at one shot, even if you
Definitely
get
not, ma'am.
10 lakhs or 5 lakhs or 2 lakhs or whatever.
They are not even in a position to.
So they will
engage
pay,
now.
we'll tell them to pay within how much time? Within 2 weeks.
How much?
You deposit 50%.
50% is not possible. 5 lakhs, your lordship.
Not possible, then you
Your
go to
lordship-
jail.
Your lordship, if I'm allowed to pay rupees 1 lakh or 2 lakh, your lordship, I
No,
can
no,
manage
no.
something, your lordship. But
No.
5 lakhs, your lordship is not
Take
possible
care of
for me.
two
Your lordship,
children's
kindly
Well,
tell your
well,
lordship,
let us see,
I am
let
ready-
us give it. You must be
LCR has not
I'm
yet
ready
been
to
received,
pay
ma'am.
for my children, your lordship. I'm paying. That actually, maybe in the main
There is no use. Yes,
I is for bail. AP.
yes. Why should bail be granted?
Till judgment manner is.
Huh?
Till judgment dated 2/5/22, he is in jail.
22, yes, he's in jail.
2/5/22,
So he's in jail, that much we know.
judgment,
But why should the sentence be suspended? That's the question.
he is only son, my lord, he has his mother, old age his mother.
Another
Yeah,
70-year-old lady has been killed, my lord, by the accused. My lord, grandmother, his grandmother,
He killed his grandmother. Why?
My lord, maybe there are conflicts, some, my lord, that is not reflected in the evidence.
Was there any eyewitness?
Yes, PW1 is the eyewitness, my lord, his younger brother.
Huh? His younger brother,
of accused,
younger brother
younger brother,
of the accused.
accused, my lord. And then, my lord.
Who is PW? Who is the younger brother of the PW?
PW1, you know.
PW1.
Then PW5 is the mother of accused. She also deposed against him. Of course, she does not, she is not
No, no,
eyewitness.
Huh? PW1 is not the younger brother. Please look. Let us
Yes.
see.
Yes,
You don't even read.
PW1. I know the accused, who is my elder brother. That means his elder brother, accused.
Where does it say? Which page?
Sorry, my lord.
Come to page 9, page 5. Para 9 of the judgment.
Judgment, one second.
Is this para 9? Yes, para 9 of the
I
judgment.
am reading from his deposition, my lord. Deposition of PW1.
You please come to my para 9.
Judgment 35. Judgment is at 9. Some judgment. Judgment is there.
Internal page 5. You don't know where 9 is.
PW1. Page 11, my lord.
Huh?
Page 11, my lord.
Page 9. No.
Yes.
And top. Please see.
Para
First line of the page.
Page 9, number 424, first line is under section 302.
Of the judgment. Of the judgment.
Yes.
Page. Okay, look at page 5 of the judgment. Page 5 of the judgment.
Page 5 of the judgment.
Internal page 5 of the judgment.
Yes,
Come to the top.
yes.
What does it say?
Para 9, my lord.
What does it say?
PW1 Srimati Monisha Sonar.
So Monisha Sonar is a brother.
My lord, I am reading from deposition, my lord. PW1 is Miss. Oh, she's sister. Sorry.
Sister. Then I no, we don't need to give it back. Give it back. So is the sister.
Her brother, her brother.
Her
It
brother,
is-
that's
it
what.
is her brother.
So you were the one who saying that is the younger brother who
Yes,
saw.
sorry.
Madam, there's what to do. There is your sister has seen you kill the mother, your mother, right in front of, and that also with a iron rod. Not only you on her hand, belly. And then she had to bow and touch your feet to save herself. Not even mother, sorry, grandmother.
Grandmother, madam. PW five is the mother of accused.
Terrible the way it's been done, my God. Huh? From the sister. Yes.
See page 17, my lord.
At first, he wanted to assault the mother, and he was restrained. Very, I should not touch. Then he made his mother touch her feet. Then thereafter, assaulted the mother also. Then this is the way he's treated his grandmother. My God. How old was the grandmother?
My lord.
Age of the grandmother deceased.
As per postman report, my lord, 70 years.
70 years.
So that doctor's evidence, my lord. That is a PW four.
Okay.
Padma Maya Sonar.
As per her mother deposition, my lord, kindly see page 17. At about 7 p.m., accused again, and then out of here, she and her daughter means Monisha Sonar,
There.
went to the house of next Sita, sister Verma. They returned to the house at about 9 p.m. when accused went to sleeping. At the time, her
Page 15.
mother-in-law was in bed and crying due to her pain. Since, as per her mother deposition, the daughter was not in house.
Wait, not page 50. Which page did you say?
Page
Huh?
17, my lord.
17?
Page 17.
No, page
In
17.
the appeal,
Huh?
internal page of the judgment is 11.
11.
11.
11 is page 11 of it. Okay. Here, the daughter accused assaulted Monisha. Sister also assaulted.
What is that? With an iron rod. But then, out of fears, with mother, she went to the house of the next neighbor.
Mother-in-law also assaulted.
Mother-in-law also assaulted. But
There is mother-in-law, there is mother also. What is this?
mother and Monisha Sorai was not in house, my lord, at that time. As per PW 5,
Who is PW5?
mother.
Mother, madam. And PW one was medically examined by PW eight. But she doesn't speak about any injury, you know. PW one. Simple injury received by her.
But but you assaulted your grandmother. That is
Yeah,
proved. That is proved.
They
That
took
is
7 year
true,
old.
but,
Seven-
sister is
70
not
years.
Huh?
As per PW 5, sister is not an eyewitness.
Okay,
So as
so
assaulted is-
so you, according to you, did you assault your grandmother or not?
assaulted is-
You assaulted. Okay, right. I heard Miss
And Decca.
NM Decca, learned counsel for the appellant. Also heard Mr.
D dash.
D Das, learned counsel, learned additional PP. This is an application under section 389 CRPC for suspending the sentence passed in the judgment dated 2/5/22 by the learned Sessions Judge, Golaghat in Sessions Case number 19/22, by which the applicant has been convicted under section 302/323 IPC. The applicant has accordingly been sentenced to undergo rigorous imprisonment for life with a fine of rupees 10,000, in default RI for 3 months under section 302 IPC, and was also sentenced to undergo RI for 1 year with a fine of rupees 1,000, in default RI for 1 month under section 323 CRPC. Yes, sir. What are the grounds?
He is only son, my lord.
Only son. Naturally, only son. Now he's the only family member also, maybe in a few years.
Order-
If he kills off his family members one at a time, then he'll be not only the only son, he'll be the only family member. What's up? Next. On considering the evidence adduced by the witnesses, which goes to show that the mother of the applicant had seen the assault made by the applicant against his grandmother, which resulted in her death. We are not inclined to suspend the sentence. The application is the application for suspension of sentence and bail is accordingly rejected. Then in the main case, you're right. As records have been received, a registry to prepare the paper book. Do you need paper book out there?
But evidence is in English, of course, without photocopy will do, by photocopy they can prepare the.
Prepare the paper book and list the matter after the vacation.
Blood.
Item number 5.
This is an application for leave to my lord appeal by the state.
Yes.
My lord. I am appealing for a respondent, my lord, who has been already acquitted, my lord. My lord, I have certain personal difficulties, that's why I take for some time. Did this matter?
No, there's nothing here. What is there?
No, my
This
lord,
is-
there has to be, because basically, my lord, what your lordship has to see is whether this judgment which has been passed in acquitting the accused is unreasonable or not. So, my lord.
So we will see that.
Lordship will grant leave. to
We'll
us,
see
Your
that.
Lordship.
We'll see that at the time of hearing. As
That-
now
that-
is only
that-
a
that
leave
is
to
why
appeal.
Today
Yes.
I am slightly handicapped, my lord.
Huh?
I have some personal difficulties, my lord. Later
What is
on-
there to do? What is there to do? What kind of submission will we make in this case?
Well, submission is
wrong?
that, my lord, the judgment which has been passed is well reasoned, my lord, because.
So we will see that at the time of
My
appeal.
lord, I also have to have my satisfaction. I am representing the accused who has already been acquitted.
Huh.
So there is a double presumption on his innocence, my lord. So
Huh.
that is why.
Yes, that will be decided
That
when
will
be
be
decided
decided
on
on
appeal.
this thing and all. So, my lord, at least, my lord, let me have that, my privilege.
Yes, madam, what is the infirmity with the judgment?
Lordship, if you consider the merit of the case, Your Lordship, here, if you like to do this, no? Lordship, 2 minor girls have been sexually abused
Okay.
by the owner.
Yes.
Yes. My lord, the evidence of the PW one, my lord, may I please that?
No, you see, basically. The court has, on the basis of the ossification test, held that 18 plus. So that means 16 years. Now, you are correct that there can be a view that why not 14, or means 16 to 4, it will become 14. But the law says that when there are two views and the one view is favorable and one view is unfavorable, then the view that is favorable should be taken. What is wrong? Then that is the crux. If that, huh? You're
That aspect your lordship
Then,
will
yes.
consider.
at the time of,
Yes, my lord, not at this stage.
correct.
Yes, my-
So, Mr. Counsel,
No, my
that
lord.
is the crux.
No, my lord, yes, that is the crux, but
So-
then, my lord.
So
my
then,
lord,
so what is wrong?
the wrong is, my
But
lord,
we'll allow this application, we'll hear this matter in a short date, we'll give you.
yes.
I will dispose it off on that That is the only, I mean,
Then why to drag the man, my lord? Because if lordship.
no,
has not
because we have to see the, this is, this is not a
Spatial review is
stage.
not something,
This-
my lord, you
no.
can just, my lord, grant it like that,
Correct.
my lord.
No, I agree. But this is not the stage
My lord,
where we can really go into the evidence. We want to see the evidence, everything.
my lord.
So
That is why I'm
we
taking
will
a lot of
allow
the
this,
evidence now,
we will allow this application.
my lord.
We'll fix it if you want.
My prayer will be, my lord, at this stage, my lord, lordship will only consider that aspect as to whether, my lord, the judgment on that account which has been passed is irrelevant without, my lord, without any justification. And if your lordship finds that, my lord, it is irrelevant, you will dismiss it, my lord. And the appeal will go along with. Why do, my lord, just admit it here and drag it, my lord?
So he's been acquitted of POXO.
Yes.
Yes, my lord.
So,
Lordship will kindly
so,
consider.
no,
Yes,
madam.
I
So
know.
what he's saying is also has some point. Is that, why to drag him back into an appeal? You know,
No,
for
that
hearing the
is
appeal,
the-
when
you
that,
lo-
no, that is the main case.
Your lordship,
Once
once your
the-
lordship
you
takes
see-
up the appeal,
Uh.
as of the appeal has not been filed. Once your lordship grants leave, then it will be filed, your lordship. Now filing number is there. Then during that time, your lordship consider this aspect, your lordship, whether we have case or not. Again, we have
No,
to argue the matter before this.
Where is
honorable
the
court.
where is the bar from taking into consideration that aspect now?
Now, as regards filing, your lordship.
No,
grants to leave to file
it
only,
cannot
my
be a
lord.
matter of routine. A person has been acquitted. A person has been acquitted. Where is the bar for us to
Lordship will
decide
kindly
whether you have
consider
got a
one more
point?
aspect. Here, one case, Suomoto PIL was pending, PIL 1 of 2019, regarding fleeing of those victim girls from the particular NGO, my lord.
No, that's a different issue.
My lord.
This is with regard to POXO Act being hoisted upon a person. Now, whether whether the acquittal of that person is correct or not, that is the issue.
Yes,
So,
that will,
so,
lordship will
madam,
consider, my lord,
just,
my-
what is the meaning of leave to appeal?
my lord.
Is it that we have to, whenever someone files it, we have got to allow it automatically?
Lordship will consider that aspect, whether is there any perversity in the judgment, whether we could make out a case for grant of leave, my lord.
No. You see, let us be very clear. There are many reasons why the acquittal may be challenged.
My lord.
One of the grounds of challenge made by you is that the age of the minor or the age of the prosecutrix could have been above 18, could have been below 15.
No, there are other aspects also.
No,
your
no, but
lordship,
that
I
is the
will
main
say.
thing. For POXO to come into play, the main thing is that the age of the victim.
Lordship,
Once the age of the victim is 18 years and above, there's no question of POXO.
uh,
Okay. Okay, so their acquittal is also under 376. So we'll see. Yes, anything else?
Yes, my lord. So, my lord, the evidence, my lord, that was, my lord, given by the courts, my lord, in the course of the trial, the evidence nowhere reflected that this, my lord, victim, that she was subjected to any of the offenses under, my lord, 376. There is no evidence to that effect, my lord. And when there is no evidence to that effect, because, my lord, what has been playing in the mind of the judge is that, my lord, when on the first occasion, my lord, the 161 statements were recorded. Even then, at that point of time, my lord, these allegations were not coming.
Your lordship, the number is money execution, FC case number 1/23.
Have you got it?
Money execution, bracket FC, case number 1/23.
Pending in the court of?
Family judge, principal judge, family court, Borpeta.
Principal judge, family court. Pending before the family judge, principal family.
Next, it is kicked on.
Basically, this, I heard everything. So that's why we said that let's continue at 2. Otherwise, if I had adjourned the matter,
It would have.
again, after a few days, I would have to again hear them afresh. Otherwise, it becomes a problem for us.
That's true.
Now I've got to write one order also now, today's order, no time. So that is what I'm having a problem in this case. It's not that,
My lord, I understood.
it's not that we don't want to
No,
hear you.
no, never. My lord,
Only
I
thing
understood.
is that I'll be
Adjustment.
hearing you partly, then I'll be hearing another party again. I see every
That
time I've got to
coming
refresh my
True,
mind.
my lord, true, my lord.
That continuity is not there.
My lord will hear it, my lord, as per my lord's convenience. However, we'll be there, my lord.
That is my only problem.
We'll proceed accordingly, my lord.
Because we thought that 2 o'clock will do your case, but then their cases, we got to understand and complete everything, the hearing by
Naturally, my lord.
1 o'clock. So we had to pass
Comply.
the order. And this bench that we're having,
Is again,
there's a lot of sitting to be done after the court work, after court hours at home, correcting, writing, looking at judgments. So what to do? I think we'll fix some other day.
Gotcha.
I think better. No point. You will not, by the time I understand the case again, it'll
It'll be
take another 15, 20
my
minutes.
lord will have it on before vacations one day, my lord. On that day, my lord, let us finish. My lord will have my lord's notes and then my lord can,
Before
vacations.
Why before vacations? Why not after? Because actually there's this side, I think he's nodding his head. He's not very, he wants after vacation. Huh?
My lord, I'll be very short, my lord. I'll give a list of dates. I'll put the records are in order. That much only, my lord. I'll have my submissions on report, my lord. The only issue, my lord, has got it, whether it's a promotion or an appointment. If it's an appointment, my lord, I need not argue further, my lord. As they are contending, it's a promotion. Honorable single judge also went with the way that's a promotion, not required. And the incumbent earlier than the present one, he was, my lord, promoted from that.
From
post
which
to
post to which post?
My lord, first it's from SAR to protocol officer 2C. And being in protocol officer, he came within the zone for consideration for secretary of Chief Justice. The names were placed, Chief Justice selected him. Because that post is,
No, so where was the issue, the starting issue?
the starting issue was, my lord, when he was.
Protocol officer, he's promoted.
That
That is not under challenge.
It's again by an option. Options are called, but there is a condition given that his seniority and his further promotions will be in SAR. So when he went to, my lord, the post of my lord, secretary, first initially this, my lord, because he was given on officiating basis, this condition was put in, my lord. Subsequently, the registry puts up a note. The Honorable Chief Justice then, my lord, writes a note on his own, drawing his satisfaction as to why the rules have to be relaxed. He relaxes the rule and confirms it. There. And the incumbent just before him, who was also, my lord, who had given his, who had also been selected in the same manner, was promoted to the rank of deputy registrar.
We had fixed it for 27th.
Lordship, 26th.
Morning.
If my lord not otherwise inconvenient, the first half, my lord, if lordship can have it. My lord.
No, we cannot have first half. The
Or rather than-
other cases have to.
The lordship.
be priority. This is only one. Those are the main work.
My lord is enjoying the criminal bench.
I've got to do my work where I'm made to sit. I'm made to sit.
That's true.
How long will it take?
I'll take, my lord, hardly half an hour. My senior, my lord, may take half an hour. And they will, my lord, take maybe 45 minutes.
And when is the time to write the order?
Take from the 1
You see,
hour.
you know my style.
Well, we'll take-
I like to at least write down the facts of the case
Lordship,
in the court.
lordship.
Whatever I decide
My
later,
lord,
that
we'll
is.
keep it for 26th and 27th, my lord. I think it will be enough.
He's shaking his head.
26, my lord, otherwise also they were supposed to do it on 26. 26 and 27, my lord, will take it.
That is the problem. Last time I should, you see, we
My
had
lord,
no
but
time to
my
write.
lord. My lord had no
No
time to
time.
take that notes, my lord.
We had no
Because
time
it
to
was
write.
already 4:15 by that time. My lord rose that day.
Anyway, okay, let us see. I think madam wants to hear the matter. Huh? No, okay, no, just tell us broadly what is the case again.
My lord, broadly, the matter is like this.
Just tell me, this is the case or? Oh, this is the one. But why am I- Some notes are here, but I've not, just let me see, what is this?
Lordship. My lord had done some rough notes.
I've written 3 pages of notes.
Hmm. Oh.
Okay, so your case was that options had been called for the post of
Protocol officer,
protocol officer.
lordship.
And he was in the feeder post for protocol officer.
Lordship. He was a senior judicial assistant.
Then,
There was a rider in that order. That
that,
his seniority would be.
sir.
Sir.
Then,
And then, my lord, this was in terms of a decision of a committee. My lord, which said that it will be done, appointment would be done, appointed by way of inviting options, but with this condition.
so we needed that high court.
Lordship.
thing. There was a- So there are no rules.
There are no rules. my lord. My lord, in the rules, this post of protocol officer was of 1999. It was given by the government, sanctioned by the government, 1999. It was sanctioned.
Protocol officer.
Protocol officer. It was sanctioned in the rank of superintendent. Now, my lord, assistant judicial or assistant of administrative officer judicial. My lord will have that note. my lord.
Okay, so this is this is a resolution passed by the High Court,
Lordship.
the committee.
So that
Now, subsequent to this, has there been any rules made?
No.
So this is still holding the field.
still holding the thing. Because this was the only thing how it will, how the entry is to be given. But in 11, my lord, that posts were encadred with retrospective effect.
Okay, they were in Canada.
Lordship. Now, if lordship can have the rules,
Here was in Canada, okay. And Canada, with effect for 99, now 20.
if my lord can have the rules, my lord. It was encadred on 8/6/2011 with effect from 25 to 99. 25 to 99 is the date when, my lord, those posts were created.
Just give me this, just have a photocopy of this. Only this is required out here.
My lord, yes, yes, and there is one more. That, my lord, says in continuation of reiterating the earlier one, my lord will have the first line,
This,
first line, my lord. In continuation,
earlier resolution,
Ah,
25, look,
7/2014.
25, 7, 2000.
That, my lord, would find at page 28N, note sheet.
And there was no point, no point for me having this, then you put it as a problem. Oh, you see,
25.
I want this.
28
January
N.
2017 and this also.
My Lord Justice
Yes.
YP, Mr.
How
Justice
much is
B.K.
it now?
Sharma and C.R. Sharma. 28 N.
So I want only this and I want this 27.
And my Lord will have one more, my Lord.
No, no. And it is the note, her note.
That
and
note,
Then the meeting.
my Lord, note is 27/1/2015, registrar's note. That is
Just
58 N.
look from just take it from there.
58 N. Because my Lord, the petitioners, my Lord, last day argued that there was a Kerala model which was adopted and which was followed here. My Lord, the notes does not have that, but yes, it was all collected, but thereafter did not.
It is
Post-
similar, that means.
It's
It
not
is similar than Kerala model. Or
No,
Huh?
Kerala model says that, my Lord, you can be reverted. If required.
reverted. Okay, you can be reverted.
Reverted.
Out
but-
here, there's no reversion.
No, there is nothing like that, my Lord, because that was a decision-making
And
process.
anyway, the PO post is one post.
What, there are two posts now. We have
The
two
second post was created when?
posts. Subsequently, my Lord,
When?
my Lord, 2014-15. What had happened was there were certain posts of administrative officer judicial sanctioned by the government, my Lord. Thereafter, my Lord, one post thereof was accommodated here. In the protocol section. Then there is a post of assistant protocol officer who comes in from the junior administrative assistant.
I think we need again some time to understand.
The only thing, my Lord, if my Lord can have the rules, my Lord, for a second.
Yes.
Lordship comes to the rules. It starts at page 637,
637.
Lordship. Before I take my Lord to the provisions, my Lord may have 664, my Lord,
664.
Lordship.
Yes,
My Lord would have 665, class 2C.
yes.
One is administrative officer, two is reporter, three is court officer, four is protocol officer, two. They are in the same cadre, my Lord. Here we have the manner of.
Same
filling-
cadre, but it is the ex-cadre post.
No, it's
It was.
now.
It
It's
was.
2C service, my Lord.
But it says the ex-cadre. Please
My
look
Lord,
at it.
it was ex-cadre, then my Lord, subsequently it was N-cadre. my Lord. That's a printing mistake, my Lord. It was N-cadre, so it is in 2C, man. That it was N-cadre on 8/6/2011.
Now, how do you say it's a mistake?
My Lord, because
Uh,
8/6/2000, I can place that document also, my Lord. It's here in record. Encadrement, no document is there. my Lord. It has been encadred. This, my Lord, maybe that's a typographical error. Then, my Lord, what happened? 8/6/2011. 25/299. Now, my Lord, a person, my Lord, there is nothing. If I may just, what I have understood, my Lord. These are the posts given.
Huh?
These are the posts given in 2C. my Lord. For some posts, in the rules itself, there is a provision how you fill it up. Some, there is no provision. Decisions of the committee holds the field. Now, once, my Lord, a ministerial employee is inducted into 2C, he becomes a gazetted employee. It's in the rules itself. He becomes a gazetted employee. Then, my Lord, if he is appointed to 2C by following that process, till he is there, for all intent and purpose, he is a gazetted employee in 2C. Now, my Lord comes to 640. Just I'll conclude with this, my Lord. 640,
640.
640, my Lord. Are the encadrement of this?
Yes.
My Lord, 3A.
Uh.
My Lord will mind the words, my Lord. The secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officers of the High Court Service belonging to class 2AA, 2B, and 2C, having a degree in law, considered suitable by the Chief Justice. So, if I am an incumbent in 2C, I automatically come within the zone for being placed before the Honorable Chief Justice for appointment, for selection. Now, what is that service that my lord would find in Rule 3 at 638? Madam? (638) Rule 3. My lord will see. The services of the High Court shall consist both of gazetted and non-gazetted posts and shall be classified as follows. 1. Gazetted officers. Here, my lord, I'll have my lord's attention at serial number 1, Roman 4. High Court.
Just consists of the answer. 2A, 2C.
1 is gazetted officer. 2, my lord, serial number 1, Roman 4, the High Court Ministerial Service Class 2C. That, my lord, in Schedule 1, my lord, 2C. Then, my lord, will have 4. Each category of service consists of so many and such posts as are set out in Schedule 1, 1A, 1B, 1C, 1D, hereto as subject to any additions thereto or modification thereof from time to time to be made by the Honorable Chief Justice with approval of the Governor of the State, where such approval is necessary. So, my lord, if I am holding a post in 2C, my lord, service 2C, it's a service. 2C is a service. Then I am a member of that service till I am there. Because I am given the status there of a gazetted officer in the rules itself. I am given the scale, which is much higher than what is there for SAR. And my lord, I continue there. Maybe because of those decisions of the committee. Be that as it may, this post in the rules, my lord, there is nothing how you will come into this protocol officer. And in the rules, there is nothing from where an incumbent in protocol
What is
officer.
the, so in these rules,
These rules. My lord.
but you said the rules had been made.
No, the rules have been made, my lord, by the committee. Committee has given
Okay.
the method of recruitment,
Okay, so no other rules.
no other rules.
So that, you mean the one that you showed me, that's
Sure,
all.
That's
So
all.
that is what you mean by the rules.
Rules. my
But that is not the rule.
Rule, no, that's an executive instruction. Because there is no provision in the rule, so you can supplement it by an executive instruction if we hold that to be an executive instruction. So there is no promotion to the post of protocol officer. It's appointed in terms of that decision. And from protocol officer, my lord, there is nothing. Next, it's not been provided for till date. Tomorrow, I don't know.
So from protocol officer
Lordship.
to what is the next post?
There is no
Secretary.
next post, madam. No promotional levy. Now, 7.3 says, 7.3A says that the post of Chief Secretary to the Honorable Chief Justice, 7.3A, 640, madam. Post of Secretary to the Honorable Chief Justice can be appointed from amongst gazetted officers of High Court service belonging to these services, madam. So he is also 2C. He's there. So in that pool that I'll not even call it a zone, in that pool that will be created, he will be also one of the incumbents. Then this will be placed before the Chief Justice.
But how can, why do you say that this will be, is it a direct recruitment? It has to be considered to be a promotion.
It's not a promotion
Why?
because shall be appointed.
Maybe the word may be appointed.
Because, my lord, the word is used in the appointment letters also. If it is promotion, my lord, then the zone has to be prescribed. My lord. Specific zone has to be prescribed. Here, there has to be a Frida cadre.
But what do you understand by the word promotion?
Promotion means advancement to a higher grade. Simple as that.
Higher grade, how will you
But in
differentiate?
service, my lord,
How will you
in
differentiate?
service, you can also have posts wherein, my lord, it's not promotion, but a direct recruitment or through an LDC examination. My lord, a limited competitive departmental examination can be held. Where from these services, people can apply. They get a
So
faster.
what is that? What do you understand by the
My lord,
word?
it's an appointment because it's not a promotion, because there is no cadre fixed, my lord, for that.
I think, I don't know, maybe promotion means
These are isolated posts, my lord. These are isolated posts. But for administrative officer, my lord, in that administrative officer judicial, there is a method prescribed. my lord. AOJ, my lord, page 665, 1. Administrative
Okay, so
officer.
according to you,
Lordship,
the impugned judgment
lordship.
is wrong in view of the fact that the learned single judge has taken the appointment of this appellant to the post of PO as a promotion,
Promotion.
which should not be done.
And my lord,
So that
further,
is, that is the starting point of the dispute.
lordship.
So
And
according to
further,
you, that is a appointment pure and simple. It's a direct recruitment, is it?
it would be a, my lord, it would not be a direct recruitment, but in service, direct recruitment between the, in the service itself. In service candidates. And my lord, because options are called for, my lord. Everybody is not considered here, my lord. If it was a promotion, 1:10 or 1:5 people have to be considered. Here, options are given, my lord. Options are taken and thereafter appointment. I'm only making that argument to show, my lord, that if he is there as a protocol officer, then till the time he is there, my lord, he will be a member of service 2C. If he is a member of service 2C, that is the end of the matter, my lord. Because then there is no selection.
So what did the single judge say?
Single judge said, my lord, that because of that rider, he cannot be considered.
Because of that seniority has to
Senior.
be counted in SAR.
Lordship. Otherwise,
So that is the crux.
correct. Because thereafter, to the post of secretary, my lord, it's only a chance of all those persons in those services starting from 2AA, 2B and 2C.
So the promotion or the promotion of this person to SAR is not in question?
It's not in question. No, not sir. To
No,
protocol
no,
officer,
to
it's
SAR is not in question.
not in question.
To PO also is not
Not
in
in
question,
question.
not challenged.
No,
So so now we cannot go behind that
no.
promotion order. So now we have to consider whether the subsequent appointment of that PO to a secretary is legal or not. That's all.
That's what, so that's the absolute thing. And my submission would be, if my lord, I can convince your lordship that he is an incumbent in 2C, then my lord, they rest, because here there is no selection. Here there is no promotion. There is no.
But then that
Gotcha.
means the decision of the learned single judge rests on the premise that the appellant is not in that 2C, grade of 2C.
My lord,
Is that-
in so many words, it has not been said, my lord.
But then that is what you're trying to say, because then when he
It's a
relies
freedom.
upon that condition
Lordship,
wherein his seniority has to be counted in
Lordship.
SAR,
lordship,
that basically is the point, that's
Lordship.
basically the issue.
lordship. My lord, here, my lord, 191, he says,
Very difficult to hear you, Mr. Council, from there.
So Learned Singhal said this, that was a temporary appointment made to him, PO. They say it is a temporary appointment,
Temporary appointment.
so you are not holding the post
But then to be a temporary appointment,
and you do not have a right this way.
but then there is no other rule for appointment to that post.
my lord, that is in paragraph 39, he says, the significance of the rider is that arrangements were absolutely temporary, where no right whatsoever was conferred upon the respondent number 5, either to continue as protocol officer or be considered for promotion to the rank of secretary to the HC. This is, my lord, in my humble submission, erroneous.
Was there any PO prior to this person?
Many.
And where did they go?
My lord, what happened is when they got promotion as AOJ, they were
AOJ?
adjusted,
AOJ?
administrative officer judicial, they were adjusted, my lord, taking the date when they were appointed as protocol officer.
Okay.
Seniority was assigned. At least
Okay.
1 or 2 incidents. Then, my,
And some that was not taken.
no, some what happened, my lord, they left. They went away.
They went back.
They went back. They went back. Because this is otherwise, my lord, a very difficult post. Both. That's the uniqueness of this post. My lord cannot attribute the qualities or the features of the general post with these two posts. So this is unique in itself. Secretary, 24/7. Protocol officer, my lord, 24. When you don't know when you get a call, somebody else comes.
That is a different issue.
Gotcha.
Their work responsibility is a different issue.
That's a factor, my lord.
That's a different issue.
Lordship.
The issue is,
My lord, if he is
What
there
is
in 2C,
uh,
for all intent and purpose, still he is there. He'll be a member of 2C, my lord. Service of, till when he is a protocol officer, because that's the method of recruitment prescribed. He is there. Till he is there. Then, my lord, under 7(3)(a), if a consideration comes, he will also be considered.
so let us consider a situation.
Where?
When a person is appointed to a post, in how many ways can he be appointed to a particular post?
My lord, he can be appointed to that post by direct recruitment, by promotion, on deputation. He can come by way of transfer,
Then limited departmental examination.
then limited departmental examination. That again would be a promotion, my lord. Maybe if that's, it depends on the rules.
Officiating,
Officiating, he can be an officiating
hoc.
person, ad hoc. But the question here, my lord, is how you come into 2C. Because 2C, the method is that committee's resolution, my lord. So whether that post is a substantive one or not, that's what in the scheme of
that
the things.
appointment,
The
that
scheme of
appointment,
the things, lordship.
whether the appointment is substantive or not.
In the scheme of the things, protocol officer. If my lord comes to the conclusion that in the scheme of the things that
You
is.
see, one
substantive-
thing is they'll be getting their pay.
Yes, everything.
They'll
Status,
be,
gazetted
they'll be
status,
getting their increments.
Gazetted status,
Just a minute.
lordship,
Now, if they go back to
lordship,
SA,
lordship.
is their pay protected?
My lord, I'll have to check up, my lord. I think, somewhere.
You see, that is
Protection
one,
for-
one indicator. When there is pay protection,
My lord, I'll check that. My lord, it's a pertinent question. I'll check that, my lord. I'll check that. I'll check that. I'll check that. But this is, I have found that this adjustment, my lord, that when he became a protocol officer, subsequently becomes a superintendent earlier, now administrative judicial. He was given seniority from the date he became a protocol officer. This was subsequent, 2-3 years afterwards.
so the respondents, I hope. So I hope you also keep tabs on this issue that whether there is any pay protection.
Lordship, I'll look into it.
You just
And-
find out.
With
Both
regard
of
to
you.
the post of secretary, ma'am,
Huh?
with regard to the post of secretary, the last incumbent before this person, ma'am, he was also, he did not have a law. He was appointed from, but that his cadre was, he was an permanent incumbent there. Thereafter, my lord, after becoming secretary, by way of this election, he was promoted as deputy registrar. The secretary is in the rank of assistant registrar. And he was also, I'll place that next time, my lord, he was also, my lord, placed.
I just want to digress. What happened to that other matter regarding your 130A?
130A, my lord, lastly, my lord, the matter was, my lord, listed. Then, my lord, we made a prayer that it should come back before your lordship.
Why before we came?
No,
to
no,
that,
no, my lord, but we made a prayer, my lord,
No, no,
but
why should you make a
unfortunately,
prayer?
my lord,
Why
my
you
lord was
burden
not
me with that
available.
case?
Was not available, then, my lord, it went to before the honorable chief
Oh.
justice. It was again directed to be listed because there was no part heard made, my lord.
Okay,
It was listed and I, under instructions, my lord, I was forced to say before the court that they will go by, but a time limit is to be fixed. They will go by the, my lord, the one-man committee's elections, my lord. The 130 was not gone into that.
that the issue was.
No,
not-
no, my lord, no.
Okay,
It was not gone.
What is
It's
it?
still,
So
still
it's-
left open, my lord.
okay, it's still, the cases are still pending.
No, no, those cases have been disposed of.
Okay.
Because, my lord, they wanted me to, because they were desperate. They were very desperate that 1 month, do it.
Because that was very interesting.
Lordship. The first was, my lord, they made a submission that because of the Supreme Constitution, the Supreme Court the amendment of the Constitution, that provision, it is not possible to go beyond 5. Then searching, my lord, I placed that That Supreme Court judgment when it said this will not be applicable to
Ah,
cooperative society,
no,
only to multiple cooperative society.
This will surprise a lot of persons, I think.
But my lord, I still believe that 130, there are two parts, my lord. I was not even able to convince your lordship to that extent, but there are two parts. Otherwise, my lord will only look into the fact when that was made. It was made, my lord, during the COVID period. And it was such a period when, my lord, nobody knew when it will end.
Correct.
So 6
No,
months,
no,
six-
no, that way, there is scope for looking into that
Lordship,
aspect,
lordship.
because
The
if the,
second part,
if the COVID had been there for another 4-5 years, then what to do?
because
That
my lord,
is the
at
only
that point of
problem.
time, my lord would remember, it was said to be there till 25. We are lucky that, my lord, it went off.
Anyway, just digressing.
That was
Just-
a lot of-
Well,
Lordship, I felt bad, my lord, because I could not take that matter to that extent, my lord,
Ah.
to get a decision on that 130 plan. Unfortunately, my lord, clients interest, my lord, what they say, I can't go beyond that.
uh-huh. No, that was basically more academic also.
Academic one. But my lord, it would have helped in
Yes,
future.
yes.
Because
would
that
have-
130 is there, my lord,
It would have clarified the entire thing.
entire situation.
Yeah.
And there would not have been scope of pick and choose, because there would be many
And
still left.
even we all came to learn that that entire part had been declared unconstitutional by the High Court and the Supreme Court,
Lordship,
which we never knew.
no, that day we came to know. I was searching through, I was surprised, how come this come?
Yeah.
Only with regard to multi-state cooperative societies,
Yeah,
is happening.
that.
Otherwise
yes,
it's not. happening.
correct. Anyway,
Lordship 26.
right. I heard Mr. UK Nair, Mr. KK Mahanta, Learned Senior Counsel, and Mr. UK Nair, Learned Senior Counsel, for the appellant,
Appellants, my lord.
appellants. Appellants.
In both ways.
Also heard Mr. J. Patwari, Learned Counsel for the private respondents,
Rate petitioners.
private respondents / rate petitioners. So, the appeals have been made against the common judgment and order dated 5/1/23, passed by the learned single judge in WPC number 1376/2019 and WPC 3845/2021, wherein it has held that the appointment of the appellant in WA number 5 of 2023 as secretary to the Honorable Chief Justice, Guwahati High Court on officiating basis and the subsequent order regularizing his services in the said post were unsustainable in law. Full stop. The appellant's case is that the appellant had been appointed to the post of protocol officer on the basis of a selection process that had been preceded by an option for being considered for the said post in terms of notice dated 2/9/2016. Full stop. The appellant, amongst others, had applied for the said post. And in the selection process, he was selected and consequently appointed. However, the appointment order of the appellant as protocol officer contained a condition to the effect that the seniority of the appellant would have to be considered in the grade of SJA,
Shall be maintained.
shall be maintained in the grade of SJ. Full stop. Then he was regularized. Was he regularized?
No. Then, my lord, on 10/9/2018, he was on selection by the Chief Justice, appointed as secretary to the Honorable.
No,
Chief
no,
Justice.
no. He was appointed on as protocol officer on officiating basis.
No. It was, my lord, appoint so and so temporarily and until further orders.
Was appointed temporarily, temporarily,
Until further orders as protocol officer.
temporarily, huh? Full stop. Next para. You see, the appellant was thereafter appointed, where is that?
My lord, it was, my lord, on 10/9/2018.
Page.
10/9/2018. My lord would have page 145 of Niroj Sharma's appeal, my lord.
The
145.
appellant was thereafter appointed
On temporarily and until further orders. as secretary,
temporarily
And
and
until
until
further,
further orders
as secretary or
as
officiating
secretary
basis.
to the Honorable Chief Justice on officiating basis.
Officiating basis. With that, again, that condition.
Rider is still there.
In the pay band of rupees 30,000 dash
1,10,000.
110,000 with grade pay of rupees 14,500. By notification dated 10/9/2018. The appellant was to maintain his seniority. No, in the notification carried a condition that the appellant would maintain his seniority in his original cadre, that is senior judicial assistant. And his further promotion will be made on that basis. Now, this aspect, okay, on that basis. So this, after this, what is happening?
Next page.
Then, my lord, next page, 146.
Thereafter, while notification dated 10/9, no,
No,
24/8/2020. Don't say that, we'll say. Thereafter, in exercise of the powers conferred under Article 229 of the Constitution of India,
Read with.
read with Rule 63, capital A of the Guwahati High Court Services, appointment, conditions of service and conduct, close, rules, 1967. The Honorable Chief Justice was pleased to regularize the appointment of the appellant as secretary to the Honorable Chief Justice with effect from 4/7/2020. Provide notification dated 24/8/2020. Full stop. The stand of the appellant is that once he has been appointed to the post of protocol officer, he comes with it. He comes within the cadre of class 2C. Roman 2, post. Reflected in Schedule 1 of the Guwahati High Court rules, which have been made in pursuance to Rule 11 of the said rule. He further submits, the appellant's further case is that in view of Rule 7, no, Rule Rule 6. No,
My lord is looking for,
I'm looking at something else. It comes that in view of rule 7,
3A.
bracket 3 capital A, bracket close, of part 2.
Yeah.
Of the Guwahati High Court Service Rules 1967. Comma. The appellant who was holding a class 2C post was in the consideration zone for being appointed as secretary to the Honorable Chief Justice.
And the appointment is made at the sole discretion of the Honorable Chief Justice.
So further,
Selection
the
and
appointment to the said post. No, comma, as the appointment is made on the sole discretion of the Honorable Chief Justice. He also submits that the promotion, that the appointment to the post of, this is the counsel for the appellant submits that the promotion, that the appointment to the post of protocol officer has been made on the basis of the resolution passed by the committee constituted for dealing with all matters relating to officers and staff of the High Court held on 9/3/2015.
read with 25/7, read with 25/7/2014.
Read with the resolution adopted on 25/7/2014.
Gotcha.
He submits that there is no service rule for appointment of protocol officer except the resolution stated above. Next part. The challenge made to the appointment of the appellant by the writ petitioner had however been allowed by the learned single judge by the impugned common judgment and order dated 5/1/2023 on the ground that the erroneously coming to a finding that the appointment of the appellant as protocol officer was a promotion. Correct.
My lord, it says, my lord, that the rider there, so it is not a, it is not
No, what have I said?
absolutely temporary.
The challenge made to the appointment of the appellant by the writ petitioner had however
Been allowed.
been allowed by the learned single judge by the impugned order common
By the single judge. By giving undue importance to the rider / condition in condition stipulated in the, where is that order?
My lord, that order, my lord, would find
Promotion, appointment order?
appointment order, my lord, it's dated 25/11/2016. You want to say 25/11/2016? 25/11/2016. No, protocol officer, my lord, page 144. 144.
Whatever it's-
The challenge made to the appointment of the appellant by the petitioner had however been allowed by the learned single judge by the common judgment and order dated 5/1/2023 by giving undue importance to the rider slash conditions
No,
stipulated in the-
by erroneously interpreting. By erroneously interpreting. The rider slash condition. Stipulated in the note, in the appointment order of the appellant as protocol officer. Where it was stated that he would maintain his seniority in his original cadre. That is senior judicial assistant. And his further promotion will be considered on that basis. The counsel for the appellant submit that the promotion submits that the appointment of the appellant to the post of protocol officer is on a substantive basis, substantive and regular basis. And as such, the maintenance and as such, the maintaining of the appellant seniority in the cadre of SJ cannot bar him from being a part of the cadre of
2C,
2C,
service 2C.
Huh?
I put service 2C, class
Like-
2C.
of the class 2C post in the High Court service. He submits that. They submit that. The appointment of the appellant was not a promotion. The appointment as a PO, as a protocol officer, was not a promotion. But what,
But my lord can say it's a appointment, it's an appointment, not a promotion, but an appointment. In service direct recruitment, my lord, if we can say that.
there are so many kinds of appointments.
This would
Direct
be-
appointment is there, promotion is also appointment.
That- Promotion, my lord, is, if we differentiate it, my lord,
There are different ways of appointing a person.
it's not a promotion distinguished, my lord, from a direct recruitment, my lord. It can be distinguished here because options were called for. And thereafter, this appointment was made. In service candidates, my lord.
What have I said?
They submitted the appointment of the appellant as a protocol officer was not a promotion, but
Was a promotion. Without there being any consideration zone.
Consideration and by inviting,
Consideration zone,
and by inviting,
limiting the number of candidates from the grade of SJ
SJ, and those who had submitted options.
and those who had submitted
Options. Okay. And my lord, if my lord is going a step further,
No, you can go, I'm not going, you're going.
no, I'm going. my lord.
It's all
My lord may,
yours, all
but
yours
just for my lord's consideration. Then he was appointed as the secretary to the Honorable Chief Justice on 10/9/2000.
You have written all that.
Lordship, one thing, my lord, the Honorable Single Judge. Because while regularizing him, the Chief Justice had given a note. The Honorable Single Judge has, my lord, questioned that on the basis of adequacy, which I say, my lord, is beyond.
Okay.
Page,
So page,
my lord would have it, starts at page 172, the note. Detailed note was given by the, then
this
my
is
lord
for
said
what? This is for at the time of,
regularization, for relaxing the conditions.
okay, so,
Reasons have been set out.
Ah.
173 para 33, my lord.
okay,
The aforesaid considerations in the opinion of
Okay,
this
right.
court while exercising powers cannot be turned to be adequate.
right. Next para. The learned senior counsels for the appellant submits that the learned single judge could not have termed the opinions of the Honorable Chief Justice
Dated 4/7/2021.
dated 4/7/2020
2020.
as inadequate. Which had been the basis for exercising his discretion and relaxing the qualification for appointment to the post of secretary to the Honorable Chief Justice,
Got it.
Guwahati High Court, under Rule 63, capital 63, capital A of the Guwahati High Court Service Rules. He submits that the discretionary exercise of power by the Honorable Chief Justice was reasonable and the learned single judge could not have substituted his view to that of the views of the Honorable Chief Justice. That's all.
That's
This is the matter on when?
26, my lord.
Once they complete, we'll submit all. They have not completed. That
Actually,
was the understanding on the last occasion also.
my senior would be placing some few judgments.
The
Probably-
problem is you won't finish. That's the problem.
No, I'll finish. I've finished up. I have nothing more to say. My lord has got my essence.
I don't know if I've got the essence, but yeah.
I could not have put it better than this one.
Anyway, so
26, my lord, let's have a try.
we'll have a try at 2
But
o'clock.
Lordship will accommodate us if necessary.
Huh?
Lordship will kindly
No,
accommodate
no,
us.
26, my lord, it was convenient for them, my lord. That's why I said 26.
But provided
On the
today
last
is
No,
not-
you see, the problem is, Mr. Mahanta has also not started.
He'll not take much time. Not
How how do you know? You
He
know,
told me, my lord, I asked him.
let him say what he has to say.
So,
I don't know.
I'll try to be as brief as possible. I must say that. I'll try to be as brief as possible.
Okay, we can try. But subject to what happens, release this matter on 26th at 2.
On the last occasion, why not?
I hope it will be finished on that day. but-
Huh?
I hope it will be finished. We'll be able to finish on that. I think they will also be, because they were pressing for early disposal earlier.
Yes, sir.
So,
Vacation is and already honorable chief justice has declared the coming week as a motion day.
Motion
Uh,
there.
no
all
hearing,
motion.
no hearing.
From Monday is all motion. But our bench, there's no motion. no.
motion, my lord, already there. And we also don't have any motion.
Our bench is all 20 years life.
But unfortunately, my lord, the learned senior councils do have motions.
We don't have much motion.
2 o'clock they won't have any. 2 o'clock they'll finish.
most of them are there, well, we will be free. So far, I am concerned.
I don't know. They'll be running around. Mr. Yukinar will be very busy doing 100-meter dash from here, this court to that court.
My lord, on the last occasion, your lordship was searching for a term similar to my lord's.
Isolated post.
A solitary post is it, my lord?
Huh?
No.
Solitary post.
No. I'll have to look for it. There,
standalone, isolated and solitary post, I don't think.
No, it's more akin to isolated, but it's just, there is some term.
Term, but I was
There's-
also researching,
also-
that, and I came across the solitary term. Supreme Court has used.
Anyway, no, there is a specific term to it.
Well, I can have the records back, I can place it.
Yes, you can take it.
What's okay?
Deeply of it.
All right.